Okay, guys, thank you so much for joining me. Certainly want to be aware of your time on this Tuesday evening. So, we will try to make this as focused as I can on getting information to you guys and then saving a lot of time for questions because trust is an important question. Trust planning, estate planning, legacy planning is an important question for a lot of people. And what I can guarantee to everyone, whether it's a will, whether it's a trust, whether you're just going to leave your things for your family to figure out at the time of your death, you're going to need to understand this. I mean, maybe you don't need to understand it, but you're going to need it for your assets. And you may say, I don't have much. And most people are actually surprised when it comes in the eyes of the law on what they do have, because it's nothing sadder than a family fighting or not understanding that they still have work to do for a very small estate. And so if you don't put the time in now, someone still will have to figure it out. And we do know that death is a guarantee in this lifetime. But the powerful part about estate planning and trust planning and why I like it is it puts you in the driver's wheel of what we know will happen. And so as an attorney, I've seen this blow up in so many people's faces, and I've seen so long where people's grandparents and great grandparents never took the proper steps. So when they do try to strain things out and fix grandma's house or get the property that you guys had in East Texas, it is very complicated. And because it's complicated, very expensive to figure out. So wanted to provide some tips on how to do it. If you're not familiar with the Curry Law Firm, there's a picture of everybody. We are a full cycle business and real estate law firm. So we understand the legal pitfalls that come from real estate. I've been in real estate for the past 20 plus years and an entrepreneur. So I understand it from a perspective of an attorney, but also from someone who's done it from a variety of perspectives. So those who are looking to protect and grow the assets they have, this is for you. And we are a firm that can help you from, I always say, the rooter to the tutor. So full service, things you need in startup, in growth, in maturity, and as you're looking for an exit strategy. And trust planning is one of those things that I think is most important when it comes to really building and protecting a legacy. So, who is this seminar for? Well, I already mentioned that everyone has an expiration date. So, everyone at some point will be passing the things they have on to other people. And that may be the home you live in. If you are looking for generational concerns, you may be thinking about setting things up so that everybody in your bloodline can get a college education or has a place to live or has medical care. For those who are looking and have minor children and want to make sure that the people that best represent them as parents, as providers, they're putting in place to care for their minor children. Of course, people with real property or business interest, those things, the law does not automatically do anything for you. If I could say anything, if you took anything away from today's webinar, I hope you understand that. Lots of people come to me and say, I was the only child, so this is automatically mine. I was the wife, so this is automatically mine. And if you do something in the eyes of the law to get it, sign a deed, go open a bank account, sign a signature form. You have to do something else to transfer it. So you will always have to do something to transfer it. And in some cases, it's easier than others. If you want to avoid automatic intestate laws, a lot of times this is for my single people, you may, or even married people, you may, what do they say? Blood does not mean that that's your kin. And the laws of intestate, if you don't have a will or trust, says that it will go to your heirs below you, and if not, your heirs above you, and if not, their heirs. So you could wind up with a cousin, a brother, a very distant cousin being the recipient of your estate if you're not careful. And of course, divorcees or anyone who's experiencing a change of life. Maybe you made a plan when you were with someone, maybe you're no longer married, maybe you're divorced, and you now have to rethink that plan to make sure it's a proper fit for your wishes if anything happened to you. So, what is estate planning? Well, I like to call it legacy planning because I like to think a little bit more forward and a couple of steps beyond just what happens immediately. But estate planning is a process of creating documents, legal documents, that plan for, if we do it right, incapacitation and death. So that could be a will, a trust, and other ancillary documents like a durable power of attorney, a healthcare power of attorney, a HIPAA form, things that leave instructions and fill in the blank so someone is not guessing what you would want if something did happen to you. So, if you're wondering what incapacitation means, it just means that you have been deemed to not have the mental authority to make decisions for yourself. So, that may just be you're in a car accident and you're unconscious. At that point, during that time, you will be incapacitated and someone would need to make decisions on your behalf. So, legacy planning is so important. One, it's not automatic. If you're waiting or trusting the state to do what's right, because lots of people come to me and say, that's not right, right? The law views following the law as what's right. Now, that kind of is against what we may make sense of in our minds. It's right that I get my mom's estate. It's right that I'm the wife and it comes to me. But the law thinks what is right is you following the rules. And so you kind of have to play to play, right? You have to understand the rules in order to properly follow them and to move things along as smoothly as possible. So you can experience huge asset loss if you don't make a plan. If you have a business, for instance, and you don't have in your operating agreement who has the right to take over that business at the time of your death, then it is moved to probate and you may have to wait several months or even years for that to be straightened out. So if there was no one driving the car to your business, what would happen? Could you pay bills? Could you pay employees? Could you keep clients? If your operating agreement hasn't planned for that, then you are at risk. Other things to consider is that you want to provide some legal direction. You maybe don't want to make your kids instantly rich if you die because of your life insurance policy. Maybe you want to enact some of the things that have been important to you in your lifetime in that plan. So you may say, college to me was important. I have a client who has a bonus to her daughter if she gets a graduate degree. I have clients who have provided that their kids always get health care and they always have access to a home. So there are ways that you can think about more than just your assets, but the grit, the intention that brought you to having those assets. And that's where real legacy comes into play. Maybe you say education is important, or entrepreneurship, or spending money wisely. You can put all of those internal beliefs into your estate plan. And so you're moving forward with your legacy, what is important to you in your lifetime. It's another way to reiterate. Hopefully this is not the first time they find out entrepreneurship is important to you, right? In reading your trust or reading your will, but you can reiterate some of the things that you've always tried to share. So if you always told people, hey, owning property is important, owning land is important, and lots of people have shown that in how they've spent their money in their lifetime, but how you kept that legacy going after your lifetime by enabling and empowering those you are leaving things to continue that legacy. And that may be, hey, I want you to always keep this land and the property, but I've provided for how we're paying for taxes, how we're paying for insurance, and how we make sure it's not lost by slipping through the cracks, right? And then you want to always avoid legal processes that you wouldn't have to pay for if you plan properly. Probate can be a very expensive process. It opens your estate up for contest, meaning someone could come in and say, no, mama wanted me to have the house, even though it was your intention to do something otherwise. But even more than the time, without clear instructions, it's almost, I don't want to say certain, but it happens in many circumstances more than people would expect, that there is some contention amongst those beneficiaries. So if you had a happy family or a big mama's house or something, and everybody seemed happy, something about the stress of death paired with the stress of managing assets can tear families apart. So why would should they have to guess? Why would one person have this opinion and another person have this opinion on what your interests and your plans were? Write it down for them, make it clear for them, and help people heal by following your instructions. They don't have to say, I think this and you think this, or you are always mean to me in the third grade, so I don't want to listen to you. They don't have to take any of those interpersonal issues to follow along with your wishes and doing what you wanted. So it is very empowering. I know lots of people don't want to think about death, but I would rather a death plan the way I want to than let people fight it out on what they think I wanted. So this gives you an opportunity to really have reach through and put things that you want in place. So one of the most common questions I get is a trust versus a will. And so I'm actually going to start with the will because that's the most common and what most people are at least somewhat familiar with. And a will happens and kind of comes up at the time of your death. And at the time of your death, you will present an original will to the court to probate it. Now, you may have instructions like an independent administrator. You may give them certain rights and waive certain bonds they need. But the will's main focus is to gather all your assets into the court and then to distribute them first to your creditors and then per any instructions you leave. So it takes everything in, it gives creditors an opportunity to say, hey, she owes me money, hey, he owes me money. And then after all that is done, you account for all the money, you account for all the expenses, you're able to distribute that to your heirs or to your beneficiaries. As you can imagine, that takes time, and courts are not naturally a fast process. There are some ways around that requirement for special cases, but in general, if you have a will, you will go through probate, and it can take however long that court takes. And if you're doing it yourself, however long it takes you to kind of get up to speed on the procedure of court. So an executor will kind of be the person responsible to review who gets what, and the beneficiaries will be named. And again, the judge will be monitoring the whole process. A trust is different because it is not dependent on your death. It does not begin when you die. In fact, the best trust should begin as you live. Many people's first trust is a revocable trust or a living trust, and it works like a box, right? So you create this box with your instructions. But in order for the box to have power over whatever asset you intend to leave, you have to put it in the box. And some things you put in the box in your lifetime, and some things you direct to the box at your death. And once you have this box, you can choose how tightly it's sealed. If you want things just to pass to someone directly at the time of your death, if you want things to kind of trickle out, if you want to keep principal in the box and distribute income, you can set a variety of instruction. It gives you the most leeway possible to say, this is what's important to me, and my instructions are a reflection of what's important to me. So it begins in your lifetime, or can begin in your lifetime. You want to begin to move assets to that box because that's how the box gets power. Just empty, it has no power, it governs nothing. But once you move things to it, again in lifetime or as direction in death, it begins to have power. And the person appointed to manage that, your executor, can begin to work through that. Now, what I like most about trust is that you are your first beneficiary. You do not have to wait to give it to your kids. If you say, when I get older and I have to use all the trust to make sure I'm in the fanciest nursing home available, or to make sure someone can come to my home and care for me, I don't want to go to a nursing home. You are the first beneficiary of some trust, right? Different trusts give you different protections, but some trust, you are the first beneficiary. So if it's going to take care of you in your incapacitation, it is available to do that. And then after that, after your death, it will begin to take care of the other people you've instructed in your trust. So I talked about the probate process, but just to give you some insight, at the probate process, you're going to, of course, if you die, you're going to have a death certificate, and you're going to present that death certificate and your original will. They're so important. If it's a copy, it does not count. It does not matter. Your original will to the court. Hopefully, if you have several versions of your will, you have restated that you have renounced any prior wills and restated this is my last will. So make sure you keep your will someplace safe, dry, free from fire, free from wetness. That may be a safety deposit box at a bank or just a little security box at your home. After you present that original will to the court, they will begin to follow the steps in your will again. They're going to gather all your assets, get claims from creditors, pay all the creditors, and then begin to make distributions to your family. It is not uncommon, although we said the total time can be a year. I've seen it done faster, but I've also seen it done much, much slower. And I've seen people who have had homes, cars, businesses stuck in this probate process for many years. So just be mindful. It is a legal process, and in general, it can cost as much, but usually more than you just doing the trust yourself. And again, their focus is on just distribution of the assets after all creditors are paid. So, and here's a quick look at the differences between a will and a trust. I won't get into the nitty gritty of that, but I will say that a trust begins now for you, so you could use it for your incapacitation. You can do immediate is a funny word. I guess a trust really is the only thing you could do immediately, because the executor would have the power to immediately begin to follow your instructions. With a will, it is immediate in the sense that at the time the court is closing your probate, they can immediately distribute assets, but you do have to first go through the entire probate process. So even things like opening a safety deposit box or paying attorney's fees, you have to request that of the court. You don't just automatically get access to those funds. Assets from a will or trust, if you move it to the trust, if you name it in the will, that's who has the authority to govern it. Another great benefit of a trust, or a difference between a trust and a will, is that a will becomes public record, which means somebody can read it, they can see your instruction, they can fight over if they should have been included, or if you named any afterborn children and they say, hey, I wasn't included, but I'm here and that's my mom or dad. While a trust is private, it's no public filing. And so, at least in Texas, someone can't come and say, hey, give me all your trust without a subpoena from the court, or give me your trust documents without a subpoena from the court. And of course, a will, you have to go through probate, and a trust avoids probate. Now, there are many different types of trust, and depending on your circumstances, will dictate the type of trust you need. But I would say the most commonly used trust is a revocable trust, a living trust. And revocable means just at any time you can change it. You remain as the executor of that trust in your lifetime. And so if you want to move things in or move things out or add to it, subtract from it, it's completely at your discretion during your lifetime. That's different from an irrevocable trust, which once you set instructions for the beneficiary, it's set, you cannot move it. What you got is what you got. But in exchange for releasing control, it is a separate entity. So that means if you have a lawsuit against you, once things are in an irrevocable trust, a creditor can't come and say, oh, I see you have $1 million, bank account, because it's in an irrevocable trust. But that means it's only for the benefit of the named beneficiary. So the main question in an irrevocable trust is, how is this benefiting the beneficiaries? So if you say, well, I have a house that I put in my trust, but I want to take $50,000 from it to buy another house. No, because it has to be for the benefit of the beneficiary, right? So it can no longer be for your personal benefit as a grantor. And then some of the other trusts, like a special needs trust, charitable trust, have a specific purpose in mind. So they work towards that specific purpose. A special needs trust works to care for either yourself or someone who is younger than you that has a medical condition that you are concerned about. And a charitable trust just means you have something near and dear to your heart, a cause near and dear to your heart, and you're leaving instructions on how to carry on your giving to that entity. Asset protection trust can also be a business trust for lots of our business owners. They don't want to put their business outright into a trust to divvy amongst their heirs, but they may want it for the continuation of the business. They may want to make sure it has special instructions. And certainly you want to make sure that someone continues to manage and run the business if you're unavailable due to incapacitation or to death. So those are some of the trusts, but certainly generational trust. There's certain tax trusts that you might put up. So there are a wide array of types of trust. So here's where you get to the good part, because this is really where you begin. The whole thing seems overwhelming, and for many people, just the idea of thinking and talking about death is uncomfortable. So if you don't want to make this like the season of doom and gloom, you can begin from a very positive way. What do you have? This can be a great way to kind of organize the things that you have. Where's my life insurance policy? What assets do I have? Does my life insurance policy cover the assets to the instructions I will want to leave? Who's important and who's good at what? I cannot say that and make that more important. Just because you love someone and they are near and dear to your heart doesn't mean that you making them in charge of something makes them good at it, right? So if your friend who is smart and thoughtful and always been your ace, but has never managed more than $1,000, if you choose that person to manage $1 million, $2 million, $3 million estate, if they mess up, whose fault is it? Theirs or yours? Because you've asked them to exceed their capacity just because you trust them. So just make sure this is a place where you can make a financial person, pick a financial person for one portion. You can pick a guardian for your children for another portion. You don't have to just say, I have 3 people in my life and those 3 people get the job, right? Pick someone who is good for the job for the job. And you may also consider things like long-term care. I can personally attest with my own mom that caring for yourself as you get older can be very expensive, and to be in a skilled nursing facility, to be in a long-term care facility, you're easily talking about $8,000 to $10,000 a month for an indefinite amount of time. So if you say I have everything all sewn up, I've planned well, and you haven't planned for 5 to 10 years of your own care, then I would challenge you to go rethink that, because you want to think about yourself first. As an estate planning attorney, I always tell my clients, what gives me joy is my clients who plan to spend every dime that they earn in their lifetime. Go on a cruise, buy the yacht, whatever you want to do. I'm for it. I love it. And you can use insurance and other vehicles to take care of your loved ones in your interest at your death. So begin with where you are. Take an assessment of everything. You'll need it for your estate plan. I'm sure your accountant needs it. I'm sure your financial planner would love to have it. And really pull this team together to manage the things that are important to you. No man's an island. People ask me about tax consequences all the time, but I don't know. I'm just a piece of the puzzle. And when you pull all of your professionals together, we're able to give the best advice on your entire puzzle instead of just pieces. So don't, feel like keeping parts of this secret or to yourself behooves you. I give the best advice when I understand the entire scenario and can give advice based on that both now and in the future. So when we create your trust, we're going to start again. You're going to do your own assessment. Do I have everything? Is everything gathered? Do I understand my financial positions? How much do I owe on my home? How much is in my 401k or any of my investment accounts? So you're going to do an assessment. Why? If for no other reason, there are probate taxes or estate taxes after a certain amount. Right now, that amount is very high. It's the highest it's ever been in American history, but that the tax code changes with every presidency. So while it's very high now, it may not stay that way. And while your assets are low now, hey, I just bought my house and I only have $10,000 of equity. Certainly in 20 years, you may have $1 million house, and it may drastically change what that estate tax responsibility is for you. But the estate tax works by taxing your estate at 40% over a certain amount. So that is just the easy way. You can imagine at a 40% tax rate, a lot of your assets could be eaten up pretty quickly if you don't properly plan. So you think you're leaving your kids $1 million, and boom, here comes the IRS, and you have much less to give. In which case your estate may have to sell some of the assets you intended to keep or give to others in order to pay the tax bill, because the IRS always wants their money and they want it on time. And a trust allows you to customize things based on your needs. So again, if you understand where you are, you can plot where you want to go with the assistance of an attorney, or if you want to try to do it yourself. So this should be customized. What I don't like about plans people find online, or they see a video about is that it may not necessarily apply to you and your circumstances. I know lots of people who are cash poor, so they say, I don't need a trust or I don't need an estate plan, but they may have shares in a business that may one day be worth $5 million, right? And so you don't want to quickly dismiss things that you have in your assets as it's not worth anything, I won't get anything, because your view of things doesn't produce income for me. I don't see a return on investment, and the IRS's view on things may be drastically different. So keep that in mind. And again, this is your opportunity to really put a spin on your own legacy. Make sure that you are playing forth things that are important to you. So there may be lessons that have passed down through generations, or you may be the first person in your family to do something remarkable, and you want to make sure you instill that same fever for education, for entrepreneurship, for growth, for investment to your kids, and maybe to your grandkids and great grandkids. So a trust is a beautiful box when created, but it's a box that does nothing. It's worth nothing. It does nothing until you fund it. So as you begin to transfer real property via a deed, bank accounts, via naming the bank account or making it the beneficiary, investments account, business interest by changing the name or the ownership of that LLC or corporate funds. And so you want to begin doing that immediately. That's the most important part, to make sure you have a trust that doesn't fail. And you have to remember that your ownership of assets changes over time. So don't forget to update the trust as things change. Some things you do not immediately put in the trust. Again, life insurance policies go to the trust as a beneficiary. 401k retirement plans go to the trust as a beneficiary. And then the 401k is to help you avoid some tax consequences if you move it too early. So here's a great example. And I know we have a lot of famous people who fall into this category. Michael Jackson has one of the, biggest estates, but I'm sure people can think of Aretha Franklin if you saw that fight, and several of other people who either did not have a trust or did not properly put their trust in a position to manage their estate properly. So Michael Jackson had a trust, but this trust was never properly funded with all of his assets. And I'm sure you can imagine Michael Jackson had a lot of assets. So still many years later, people are still fighting about it because it was so substantial. So he did a very smart business and artist move by buying his and catalog and the Beatles catalog from Sony. However, because his estate wasn't properly funded and it didn't have a plan to match his interest, they ended up having to sell that back. And if you can imagine how powerful that catalog of music was, and now while the family had the funds from it, they don't have the assets that can continue to generate funds over time. And those are the things, the real gems of having a trust and building a legacy. So you want to make sure you properly fund your trust and that you revisit that trust year over year as your assets change and as your beneficiaries and responsible parties change. Maybe your best friend was responsible and 5 years later, she's not your best friend anymore. Or maybe your mom was the party that you had watching your kids and she's no longer able to care for your kids the way you would expect. So make sure you update your interest as life changes. And one things we know is that life will change. This is, to me, the fun part, where you get to talk to your family or your trustees or your beneficiaries about what the plan is. It should not be a mystery. I just read an article from Warren Buffett where he recommends, hey, make people part of the plan, give them their role, prepare them for that role. You're in charge of financials. This is how much money I have. These are the types of investments I like to make. Don't make that a mystery. This can be a learning lesson that you can use to build your family up, to instill those lessons. So it's not just on the paper and they don't just say, okay, I only have $5,000 from my mom's trust. That sucks. They understand the why towards it, because if not, one, it breeds resentment, and two, it still breeds mismanagement, which is what you don't want. And can be some of the saddest things as an attorney, as I see someone who had great thought around building a legacy, but did not have a great plan. And then they're still left with a plan, unfulfilled, and people doing the exact opposite of what they wanted and how they to spent their money. So if you're very frugal and you've spent your lifetime to accumulate your assets, just think about how you'll be rolling over in your grave if someone just said, oh, 2 Lamborghinis and that's it. And that's the end of what you spent a lifetime building. So choose people who are responsible. It could be someone you know or a third party fiduciary that you don't know, especially if you're thinking about trust that lasts generations. You probably won't know people generations to come to follow your wishes. So choosing a fiduciary may be a great way to make sure your interests are managed for decades to come. Of course, there's a fee for that. So make sure you understand the fees and you can properly plan and put those fees and the cost of that into your trust. Again, update, update, update. It's a plan, it's in place. It's meant to be catch all, but things are forgotten. Life can get in the way. So as life changes, I would say every couple of years and more frequently if something changes, someone you love or who was in your trust dies, you are married, divorced, have new kids, have a new business, you sold an old business, you've moved properties. Make sure your trust is a reflection of your life as you grow, get older, and your own circumstances change. And I would especially say to someone who is, in their 50s and looking forward to retirement, what happens, some types of trust, like a Medicaid trust, are really best worked on early on. Right. So at the time you have cancer and you need to go to a skilled nursing facility for a long-term period, you haven't set it up in your trust, Medicaid might say, you make too much money. Why would you need us? You pay for it yourself, which could liquidate your assets very quickly for your own needs. And so then you don't have money to care for your kids. You don't have money to care for provide for your health care, and you're stuck because there wasn't a plan in place and you didn't follow up on how you actually get that plan done. So our estate planning process, I'm all about the questions. I ask people lots of questions, and I'm also about the education. So if you estate plan with me, I'll be like, why don't you do this? Why don't you do this? Here's some information other clients have used. Really, because this is a legacy to me is big on planning. Wealth creation is big on planning. And so you kind of have to, you know more to do more. So a lot of this is going to be educational and just really understanding what you want to share with your family, and hopefully bringing them on the process, selling them on it. So they're as excited that, hey, our family really is going to have a legacy and we're going to see this legacy throughout the generation, hopefully continue to get stronger and to grow. So this is the part where you can shoot over any questions you might have in the comment section. I will probably try to answer some commonly asked questions because I do this a lot, so I get this frequently. And I do want to mention before we answer any questions people might have that we do have a special offer today. We're offering people 20% off if you book your trust planning today and pay your retainers. So we wanted to offer that to people. As the year begins, often year gets hectic, you forget, hey, I want to do this. Hey, it's important to me. So that today might be a great day to say, hey, I'm going to lock in. I want to put a plan in place and I'm going to start today. But as far as commonly asked questions, I guess one, how can I transfer my home into a trust? I get that a lot. Lots of times people's personal property, their homesteader property, is transferred to a trust through a deed called a transfer on death deed, a TOD. And that's because you do have a mortgage. Most people have a mortgage, and that mortgage usually has some sort of clause that says, hey, don't change ownership. So in order to avoid that, we do a transfer on death deed, but you can also change that deed at the time that the mortgage is paid off. And certainly you can move things directly to a trust, but depending on your plan, it may complicate things. Right now, I think most people live in their house between 5 to 10 years. So it may not be your long-term plan to keep that home. So that's how we would transfer your real property to the trust. Another question I get frequently is business interest. And we do that by transferring the interest, not the management, of your business to the trust. So if you have an LLC, that will be a transfer of your membership interest. And if you have a corporation, that will be moving the shares to your trust. And so your trust can be the owner, but you can retain management, and you can even give yourself some payout bonuses or options if you have an irrevocable trust and you're kind of worried that things will be stuck in the trust that you can't get out. Another question I commonly get is, will putting things in a trust make it so it can't be seized at the time, or creditors can't get it, or that is judgment proof? And it depends on the type of trust, but certainly the most popular type of trust, which is a revocable trust, is not judgment proof. If you have a business you're concerned about, you are better off with the limited liability protection of an LLC or the kind of limited liability protection of a corporation than you are a revocable trust. That is much different than an irrevocable trust. But again, that trust is only for the benefit of your beneficiaries, which may be your kids or, whomever. So a trust, I see it all. There's some sort of social media going on that any trust can give you that protection, and that's just not true. But there are trusts that can provide. And then another question I get a lot is, okay, I have this one trust, but now I'm moving forward and I have different interests. You certainly can get different types of trust to address different issues. One may be special needs for your own care, or the care of a loved one who will need perpetual care throughout their lifetime. But you could get an irrevocable trust and a business trust and a revocable trust, right? You can pair the trust because each one is specific to a special purpose. So there's no restriction that I have this one type of trust, and so I can't get, or I wouldn't get any other kind of trust. So we have a question about when you're cash poor. If you're cash poor, again, you're assessing your assets, and you may be cash poor, but you have a $10 million policy, right? When I was in my 20s, I got a $10 million policy. That thing was like $20 a day, right? And so if you are cash poor, you want to, one, understand what you have now, and two, you want to understand how those things could grow in the foreseeable future. Right. So if you just bought your first home and you have like $2 of equity, but that's going to continue to decrease every year, you still want to have a plan in place for what happens. And I would say choosing the people who are in charge of things, irregardless of your cash position, is important. I know my mom was my power of attorney for many years. She's not in a position to do that anymore. Who else would I want? Because the law says your siblings, I don't have any, your parents, they can't make that decision. And then where does it go? If you're uncomfortable with that mystery, don't let it get to the point where they're looking for someone to sign to allow you to do surgery, because you do need permission to do that. So don't make that a mystery. If you're wondering what's important, I would start with you. You're important, and you want to put in place what would happen to you. And then if you're saying, okay, well, I don't want to spend a lot of money on a trust that's very specific, then I would say second best is put a will together and just name what's important to you, understanding that it will only come up at the time of your death. Next question is, can my beneficiaries take my executor to court if that person is withholding funds being made from the assets listed on a will? Okay, so probate is automatically a court procedure. So if someone is challenging, they can challenge your will, and they can challenge your instructions, or they can challenge the beneficiary in court with your will. If you have a trust, you can do something called putting a trust protector in. And that is just if someone suspects things aren't going right, someone is mismanaging the funds, a trust protector would be a neutral third party who would come in, audit essentially, and make sure things are going as you instructed them to. But if you're talking about a will, then the court automatically has some governance. And so if someone came to challenge your will or presented a motion that there was some mismanagement, they would have the authority to either remove them, to appoint somebody else, or to do something like make it dependent, which means every step that and a dependent administration in probate means everything that that administrator wants to do has to get approved by the court. But of course, that can become a lot more expensive, because everything they want to sell sell this property or transfer this or distribute this, they have to ask the court for permission. You have to have a hearing. And usually that portion, if it's dependent, you want to manage with an attorney, a probate attorney. Are not allowing the beneficiary listed to enjoy the assets of the will. Again, the will process, they only get the benefit, the beneficiaries only get the distribution at the end of the process. They really don't have much rights in the in-between time. So gathering the assets, getting a list of the creditors, distributing to all the creditors, doing the final accounting, and then distributing to the beneficiaries. So they don't have rights to those assets until that time, until the court has said everything has done to finalize this estate, and now you guys get what they wanted you to have, right? And that already sounds like a more complicated process. So if I transfer my LLC interest to my revocable living trust, does that impact how I can freely use the distributions from my LLC if my kids are also beneficiaries to the trust? In a revocable part, you are your first beneficiary. So you are the executor and you're the beneficiary, and technically you're the grantor. So all the things you want to do, you can do. You can fully transfer things in and out. You can make things payable to yourself. You can transfer things. If you have the business in the trust and you sell it and you say, now I'm giving myself $1 million bonus for being an awesome business person, you can do kind of whatever you want, which is why most people like to start with that type of trust. Now, if that, I guess to give a variation on that, if that was or maybe you're asking, okay, if this was an irrevocable living trust, then if the children are a beneficiary, you would have to do with that business sale things for the benefit of your kids because they're the listed beneficiary. Now, for your kids and for you, it's creditor proof. It has some additional protection and cushion around it, but it has to be for their benefit. The way around that is to put in your operating agreement, hey, I'm the manager, and me as the manager, if I take this business I started with $2 and a dream and sell it for $20 million, as a manager, I'm going to give myself this distribution. I'm going to do a distribution of 90% of the income to me as the manager for growing the business, while the remaining shares go to the owner, which would be the trust. Okay, guys, thank you so much for your time. Thank you for your attention. You'll get an email. I would love your feedback on if you enjoyed the trust, if you took anything away from the trust. So we will be sending that out. I would really appreciate it if you completed it. But I don't think there are any more questions. So I thank you so much for your time. I hope you learned something. And again, if you have any questions on trust or estate planning, feel free to reach out to the Curry Law Firm.